Hi, I'm Laura Grabouski, a 20-year lawyer and a partner with Holden Litigation. I'm coming to you live today from Austin, Texas. This webinar is being recorded at 8 a.m. Pacific Time, 11 a.m. Eastern Time on Thursday, March 11, 2021. Texas had hardly begun to thaw out from the big freeze when news reports circulated of thousands of claims being reported to property carriers. Auto carriers also faced many claims due to many accidents on icy, slick roads and property damage to autos. Now, hundreds of thousands of claims are anticipated, and this will be the biggest claims event in Texas history. Texas bad faith law has largely arisen in response to prior big storms. For example, the tort reform statute known as the Hail Bill that passed in 2017 in the Texas state legislature was implemented specifically to address hailstorm litigation that increased 1,400 times between 2011 and 2014. As many of you know, that statute brought needed reform, reducing the amount of penalty interest for late payment of claims, and also requiring substantive pre-suit notice. On the other hand, the seminal USAA versus Menchaca decision that was handed down by the Texas Supreme Court the following year solidified treble damages for bad faith. Also, Hurricane Harvey, which hit in 2017 with disastrous effects, those claims are still winding their way through the Texas court system. And we know that the Texas Big Freeze claims will be no exception, except likely more challenging due to the volume of claims and many changes in Texas law that have occurred in the last several years. Now, all aspects of the Texas Big Freeze are changing. And so these are our current thoughts and advice and recommendations of Holden Litigation as of today, Thursday, March 11, 2021. So if you have a specific question, please feel free to call us and we can answer that in more detail and as things develop. Also, we invite you to visit our website where we have an entire section dedicated to Big Freeze Texas 2021. And there you can see resources, articles, information, and links. We also have a button where you can email us questions that way. And we're keeping this very updated in real time as things develop. We also have something that's a very popular feature is our county favorability maps. Our clients refer to these as the heat maps. And for Texas, we have, of course, over 250 counties in Texas. And so you just need to hover on the particular county and you can come up with specific information for that venue, which, as we know, is very important when you're assessing litigation. If you have a question during today's presentation, please type it into the Q&A box. Our presenters will do their best to get to it during the live presentation, but anything they can't get to, they'll respond to you via email. And now I'd like to introduce you to today's panelists. Please meet Kristen Lawhorn. She is the managing partner of Holden Litigation's Texas offices. She is a graduate of SMU Dedman School of Law and has been recognized as a super lawyer's rising star in Texas for the past 3 consecutive years and is an 11-year lawyer. Kristen, welcome.
Thank you so much, Laura. Thank you for having me.
And last but not least, Steve Holden. Steve is a 40-year lawyer with an extensive amount of trial experience, totaling over 200 jury trials. Is that a typo, Steve?
No, I'm afraid it's not. And most of those were in the early part of my career where I'd try 12 to 20 a year. Now I'm lucky to try 1 or 2 a year. So, but yeah, I'm like farmers. I know a thing or two because I've done a thing or two.
Excellent. Well, and you are also president and founder of Holden Litigation, an esteemed attorney, speaker, and businessman, and we welcome you to the presentation.
Thank you, Laura. And Laura, thank you for putting this all together. You've done most of the writing and pulling it together. Laura does our research and writing in Texas and also works the claims, but she's, you always, people who know me like to know who is really the brains behind the operation. Well, that's Laura and Kristen. So thank you, Laura, for your work.
Thank you for that. And without further ado, Kristen, will you please kick it off for us?
Thank you, Laura. If you are viewing this webinar, you may be asking yourself, what is bad faith? Today, I will walk you through some real-world examples and you can be the judge. In our last webinar, Steve discussed many of the statutory violations that we usually see plaintiffs plead, and those include misrepresentations, failure to provide a reasonable explanation of coverage, and demanding a full release for only a partial payment. But at the end of the day, bad faith can be boiled down to an insurance company's failure to attempt, in good faith, to effectuate a prompt, fair, and equitable settlement of a claim when the insurance company's liability has become reasonably clear. It is also when an insurance company refuses to pay a claim without conducting a reasonable investigation of that claim. Now, insurance companies do have to adhere to a reasonableness standard. And the reasonableness standard requires an insurance company to prove, affirmative and reasonable conduct. Now we are ready to have a little bit of fun. We're going to play a game, okay? I am going to give you some examples and you can guess whether Texas juries decided that the claims handling was reasonable or not reasonable. And as I give you some of these examples today, you may pick up on a trend, but I don't want you to think that bad faith claims are rampant in Texas, because they're not. We just want to highlight these because it is very important and we want you to be cognizant of the fact that bad faith is out there. And I don't want you to have any fears. I am here to walk you through examples to help you identify when bad faith occurs. So let's go on over to our first example. This case dealt with some property damage related to Hurricane Ike, which ripped its way through Texas in 2008. So here, there was damage to a commercial office building that was valued at $4 million replacement cost. United International Insurance Company paid insurance proceeds of $2.2 million on March 16th of 2009. They then paid an additional $222,000 on November 23rd of 2009. At trial, the dispute was whether or not United should have paid more, and whether if they were required to pay more, they should have done so by March 16th of 2009. Testimony at trial included that the insured's public adjuster agreed with the estimate prepared by the insurer's building consultant. But instead of using that estimate, United paid an undisputed amount based on a separate, not agreed estimate that was prepared by their adjuster. So the question in this case is, do you think that this is an example of bad faith? Drum roll, please. Yes, it was. The jury found that United should have paid an additional $300,000. They also found that United committed bad faith by seeking a full release in exchange for only a partial payment and failing to attempt to a good faith settlement of a claim for which liability was reasonably clear. Here, the jury assessed an additional $1 million for United's knowing and intentional conduct, but it was later reduced down to $600,000. I do want to draw your attention to the fact that the jury also awarded $159,000 in attorney fees and $178,000 in interest. It's so important to note the fact that attorney fees and interest are certainly at play when you have a bad faith claim. Our second example involves the 2012 McAllen, Texas hailstorm. Here, the hailstorm damaged the insured's wood shake roof. The plaintiff presented expert testimony that indicated that the independent adjuster had made errors in his or her estimate. The plaintiff also argued that the independent adjuster did not inspect the entire roof, and the plaintiff contended that the adjuster assigned the wrong difficulty factor and used outdated pricing rates. The plaintiff was really upset in this case. And they also alleged that the criteria for whether damage exceeded the replacement threshold actually conflicted with the carrier's own protocol. Notably in this case, the insurance company's engineer did not even go out to the premises to inspect the roof until 9 months after the storm. And then when the expert engineer did go out to the premises to inspect the roof, they inspected the roof from a ladder and never actually went onto the roof. The company adjuster also failed to contact the insured's engineer to resolve some pricing and scope discrepancies, despite that being the insurance company's own protocol and procedure. This equated to a blatant failure to communicate on so many levels. The adjuster also failed to provide the insurance company's retained engineer with relevant photos from the insurance company's underwriting file. Those photos would have shown that prior to the storm, the roof was in really good condition. So it would have also helped to undercut the insurance company engineer's report that said the damage was not related to the storm, but was just due to normal wear and tear. So do I even have to ask you, was this bad faith? Absolutely. Was the conduct knowing or intentional? Yeah, it was. Because the adjuster knew that the insured contested its spot repair theory, but the adjuster failed to further communicate with the insured's representatives. The jury ended up awarding actual damages of $776,000. They also determined that the insurance company should have paid $76,500 more than the undisputed payment amount that they had paid. So that example leads us into our next one, which is example number 3. And this one also involves Hurricane Ike. Here, there was a homeowner who had called her homeowner's insurance company, and she reported that the hurricane had left significant damage to her property. So in that case, the insurance company went ahead and sent out an adjuster to investigate the homeowner's claims. The insurance company's adjuster did find that there was some minimal damage. And then based on the adjuster's findings, the insurance company determined that the policy did indeed cover those damages. However, the insurance company declined to pay any insured benefits to the insured. And right now you might be questioning that and wondering why. Well, the insurance company's reasoning behind their failure to pay any benefits when the adjuster and the insurance company determined that the damage was related to the storm was because the insurance company said that the total estimated repair cost did not exceed the policy's deductible. So about 5 months after that decision was made, the insurance company went ahead and sent out a second insurance adjuster to re-inspect the property. The second adjuster pretty much said exactly what the first adjuster said, and this did not leave the homeowner feeling very happy, not at all. So eventually this led to litigation. The insured sued her insurance company for breach of the insurance policy and for unfair settlement practices in violation of the Texas Insurance Code. And in regard to the damages that the homeowner was seeking, here she wanted the entire policy benefits, all of them. She also wanted to be compensated attorney fees and recover interest as well. And as you recall earlier, we did discuss that in these bad faith cases, a claimant can recover attorney fees and interest, and that's exactly what she asked the court to award her in this case. The parties eventually went ahead and this case was tried to a jury. Question number 1 of the jury charge, which addressed the insured's breach of contract claim, asked whether the insurance company failed to comply with the terms of the insurance policy with respect to the claim for damages that the insured had filed related to the damage she alleged was related to Hurricane Ike. So in response to that question, the jury came back and answered, no, they didn't think so. That then led the jury to question number 2, which addressed the insured's statutory claims. The jury was asked whether the insurance company engaged in various unfair or deceptive practices, including whether the insurance company refused to pay a claim without even conducting a reasonable investigation of the claim. So in response to this question, the jury did answer yes. That led the jury to question number 3. And question number 3 asked the jury to determine the amount of the insured's damages that resulted from either the insurance company's failure to comply with the policy or its statutory violations. And it was going to be calculated as the difference, if there was a difference, that was between the amount the insurance company actually paid and what the jury would determine the insurance company should have paid. So for this one, the jury came back and answered $11,350. So after that, both parties moved for judgment in their favor based on the jury's verdict. The insurance company argued that because the jury had failed to answer affirmatively to question number 1, which was that the insurance company had failed to comply with the policy, that the insured could not recover bad faith damages as a matter of law. The insured, however, was arguing the complete opposite. The insured argued to the court that the court should enter the judgment in favor of the insured because the jury had answered affirmatively to questions number 2 and number 3, and that they didn't really need to answer affirmatively to question number 1. So the trial court ended up altogether disregarding question number 1, and then they entered a judgment in favor of the insured based on the jury's answers to questions number 2 and number 3. So the Court of Appeals affirmed the trial court's decision, and then the Texas Supreme Court stepped in and they granted the insurance company's petition for review. So the question here is, did the Texas Supreme Court find the insurance company acted in bad faith? What do you think? Well, I'll go ahead and answer that one for you. So here, the court indicated that because the loss was covered for the amount of the damages, the carrier could be liable for bad faith for their failure to fully investigate, to reasonably investigate, and to find that there were additional damages. So that's definitely a case you want to consider and certainly think about as you're identifying when bad faith occurs, because there's definitely a line and it's hard to sometimes identify. But in this case, the court did decide that there was bad faith. So we are now to our fourth and our final example. So this one, surprise, surprise, involves more damages related to a hurricane. So here, an oil well sustained significant damages due to Hurricane Rita. And if you recall, Hurricane Rita was also in that time frame several years ago. And it's just like there's so many hurricanes in Texas, you can barely keep up these days. But here, the repair costs for the well ended up costing about $17.5 million. So the insured co-owned the well with another party. So when they got the total estimate for repairs at $17.5 million, they agreed to just split the damages. So the insurance company ended up making a partial payment of nearly $2.9 million. So you probably guessing it, the insured was like, wait, what's up with that? Where's the other $5 million? So after lots of dialogue, some heated words, I'm assuming, the insurance company and the insured, they just kept going back and forth and really couldn't decide over whether additional expenses were actually covered under the policy. So this resulted in litigation. The insured initiated litigation, and when it was initiated, the litigation that is, it focused on the costs related to the Wells platform because the Wells platform did need to be repaired. So the question was whether or not the costs that were incurred beyond the policy limits of the section dealing with the repairs to the Wells platform, whether they could be paid under any other portion of the policy. So they were disputing, over the interpretation, the meaning behind the policy and where the damages being covered due to the platform losses would actually be covered. So the question presented in this case was, does a dispute over the meaning of a policy bar bad faith damages? So that's actually a pretty good question, but here the court decided no. The court held that a bona fide coverage dispute is not a defense to all settlement claim violations. Concerning the damages in this case, the Texas Supreme Court did not find any evidence that the insurance company acted knowingly. So the Supreme Court ended up overturning the trial court's award of treble damages, which had been awarded. The Texas Supreme Court also reversed the portion of the judgment that awarded Insurance Code 542 prompt payment damages at 18%. 18% is pretty high. And aside from that, though, the Texas Supreme Court pretty much affirmed the remainder of the trial court's judgment, and that included an award of $1.9 million in actual damages, about $2.7 million in actual damages with 5% interest on top, additional damages for the insurance company's knowing violations of the Texas Insurance Code, which totaled $3.6 million, and then attorney fees totaling $1.4 million. So when you add that all up, you got a $9 million award in this case, which at the trial court level had actually been around $19 million. So this is a case that, you know, in the insurance world, we really need to be looking at, because that is a significant, I mean, the attorney fees alone were $1.4 million. And, you know, you question that the insurance company probably didn't go into this situation intending to commit bad faith, which is why it's important to talk about these cases and to note some of the Supreme Court opinions that are coming out. So in this case, it is also important to note that the insurance company made an unconditional tender, and the court determined that this defeated the insured's claim for damages for interest on the obligation occurring from the date that the tender was made. So that's just a little side note for you. You know, as we kind of went through these 4 examples, there's a lot to unpack. It's been fun giving you those examples and kind of playing along, and I hope that you scored well and were able to identify when bad faith occurred. But if for some reason, you know, because bad faith is tricky to identify, if you are struggling in that area or just kind of want to know more, you know, litigation here, we are very happy to answer any questions you may have, because we certainly don't want a situation where bad faith is involved. And we had a lot of experience in being able to identify that. And these 4 examples highlighted some of that. So if you have any further questions, obviously during this webinar, as Laura said at the beginning, you can ask us questions today, but don't hesitate to contact us in the future. It's been fun going through those with you. Like I said, it's a lot to unpack. But the fun's not over. You know, we have round number 2, and Steve is going to go ahead and take it away for us.
Yes, Kristen, I hadn't read your presentation before. The last case, you said it was basically a $19 million verdict when it's all added in, $19 million. And then the insurance company won it on appeal, and it was $9.9 million.
Yes.
That's called a win?
That is a win.
And how much did you say the actual damages were?
In that case, when it eventually went to before the Supreme Court awarded almost $1.9 million in actual damages.
Okay. So we had a situation where 1.9 million became an eventual payment of 9.9 million plus defense costs.
Exactly.
Okay, well, I'm glad I was listening, because that kind of proves my point. It can get expensive in Texas, folks. Thanks, Kristen. Appreciate it.
Thank you, Steve.
Yes, ma'am. Steve Holden here, here to talk to you a little bit about bad faith. I have tried a bunch of cases. Bad faith, 5, 6, 7, they don't get tried very much. I haven't tried one probably in 3 years. I've been lucky. I've had a couple of hung juries and some defense verdicts. So far, I haven't been hit. I will tell you here at the beginning, the worst thing, and this isn't even in my presentation, but after hearing Kristen's, I'm going off cue. The worst thing that can happen in bad faith litigation is not getting the full attention of your carrier and the full attention of your claims professional. These things can get out of hand. It takes a lot of preparation to be ready for your deposition. Most firms don't do what we do, but we're going to meet with you on 2 separate occasions, weeks and weeks before your actual deposition. And if things still need help, we will then, we've got an outside psychologist who's a jury psychologist. He does my research trial work too. And then we bring that in. Why all of the hoopla? Well, folks, to the jury, our claims professional is our company. And if we don't come off well there, it's an uphill battle the rest of the way. I had last week in a bad faith case, I wasn't defending this carrier, but they didn't prepare their claims adjuster. He had like 7 notes in his file, and that's all he'd read. He didn't read the other depositions. He didn't read the pleadings. He didn't know what had happened. There were things that were in the petition that he had not read. That is a killer. He denied the claim in, get this, 32 minutes. He made 2 calls and denied the claim in 32 minutes. Obviously, you can't change when the denial is already done and out the door, but to then not properly prepare, there's not a criminal statute for it, but I'd like to write one. So what I'm telling you folks, I actually get the most pushback from my clients, the companies, about the time I need to spend with the claims professional getting them ready, and sometimes even using outside help. So if you remember, not a whole lot else I'll tell you, that's critical. If we're going to win, we need to do that. And folks, we need to win. Okay? You heard Laura tell you that Texas went up 1,400%, not 14%, 1,400% between like 2011 to 2014. It is big business in Texas for these plaintiff firms. You know, the Merlin Group and others circle around. Settlements have gotten higher and higher because they don't think the carriers will try the case. We're going to have to try some, folks. We'll pick and choose, but we've got to get in there and start fighting back a little bit. That's just my 2 cents. Let me get to my presentation now. Start out with some good news. Back in 2017, the Texas statutes came into effect called 542A. It's really, we call it the Hail statute. It gave us a lot of protections and things we need to use effectively. All right, what is that? Well, first they have to give us 61 days notice that they're wanting to file a suit. That's an advantage. They have to tell us their acts and omissions that they're complaining about, so we can check them out. They have to tell us the specific amount alleged that we missed. Now, hopefully we've made our partial payment, and so we're really only arguing about the middle ground there, and hopefully it's not a big slice, but they've got to tell us that. And then they also have to tell us the attorney fees to date. If you noticed when Kristen was talking about how that last case just stacked on and on and on, that's most states that I deal in, quite frankly, but Texas is as ornery as any of them about letting it stack up and up and up. Again, your plaintiff lawyers want that to happen. They want to get it filed. They want that interest running. Now, once they give us notice, then we've got about 30 days to reinspect. If you need to reinspect, please do so. Consider whether you want it reinspected by the original inspector or if you want a second inspection. I recommend a secondary inspection. First, it's already clear they want to sue, okay? There's can be a lot of problems with the first inspector and how quick he was and what he did. The second inspection can help correct for any of that appearance of impropriety by having someone else go out and reinspect and look at what our inspector did, look what their inspector did, see what their PA may say. I don't want to get off into PAs because I'm not a huge PA fan. Never helps to get things settled. So that is number one. Jump in, jump quick in that 61 days and don't dally. I would recommend when you get that notice to get your attorney lined up because it's already locked and loaded on the plaintiff attorney side. Okay. Now, Laura, I think in the beginning mentioned Menchaca. That's a Texas 2018 case. Remember, the hail statute came in 2017. 2018, Menchaca came down. That caused the reemergence of bad faith in Texas after about a 30-year dormancy. Before that, even though it's on the books, it was hard to get it through to a jury. Most of the judges threw it out. That isn't happening now. Our jury pool, strike that. Our judicial pool has changed on us. The Supreme Court is still good, okay? That's our ace in the hole. That's what we threaten, Merlin and everybody else with about. But yeah, but when the Supreme Court gets it, they're going to knock this down. But the judges have overwhelmingly gone to the more liberal side, the Democratic side. I have nothing against Democrats, but it just happens that way. In Harris County, Houston, where I practice too, I think they had 14 new judges 2 years ago, all female and all liberal Democrats. Now, I've been down there in front of them, and actually they're trying to do the right thing. So I really don't have complaints, but at the end of the day, all the close calls will go to the plaintiff side of the bench for them, and they're all close calls. So in the end, your jury is going to get to look at it. With Menchaca, what came in is that they really put some teeth into our Unfair Settlements Claim Practices Act. That is what plaintiff lawyers first point at that we violated so they can get into their bad faith series. Number one, on the Unfair Settlement Practices Act, a lot of these things are very common to you. Some of them are obvious and easy to avoid, and some of them are in the eye of the beholder. Number one, can't misrepresent material facts or policy provisions. Sounds simple. I'd say a third of the bad faith cases I defend, there's complaints that we've misrepresented the policy provisions. We didn't tell them that on an ACV policy they got overhead. We didn't tell them they got their taxes. So we hid, we hid these things. And so when we went in to settle, of course they settled for too little before the PA helped them out with it. Number two, fails in good faith for a prompt, fair, and equitable settlement when liability has become reasonably clear. Folks, the plaintiff attorney considers it reasonably clear just because they're on the job. That's in the eye of the beholder, and the beholder in this case is juries. All right. Number three, fails to timely affirm or deny coverage. I've seen some folks kind of wishy-washy on coverage, trying to get the claim resolved and not really coming out and saying whether they're denying parts of it or all of it. Don't do that. I mean, it's the low-hanging fruit for the plaintiff attorney. Number four is an old one that I hadn't seen in a while, but I saw it 3 months ago from a bad faith case I got in. It is undertaking to get a full release when only a partial release is what is appropriate. In this particular company, and we used to all be this way. It was on the check, full, final, and complete settlement. And in the old days, I saw carriers stand on it and say, no, you signed it. You should have read it before you signed it. And in 20, 25 years ago, we went on that. We get our ass kicked on that now. So don't even think about it. Look at your checks, make sure they're straight. And when you're discussing things with the plaintiff attorney, make sure if it's not for full settlement. Don't leave it up for the plaintiff attorney to write you a letter to put in your file. Then the number five is kind of the catch-all, refuses to pay without a reasonable investigation. In 100% of the cases I deal with on storm claims, it's always alleged we did not do a reasonable investigation. How can they tell? Because if we'd have done a reasonable investigation, then we would have agreed that they needed a new roof, even though there wasn't a storm within a mile of the structure. So they have it, they can get there, they do get there, and then the jury gets to decide. Now your next question is, how are the juries in Texas doing? I'm okay with the juries in Texas. I even think the Valley is getting better. Don't take me wrong. I'm not saying the Valley is good by any stretch. And it's still very dependent down in the Valley who the plaintiff attorney is and who the judge is. But it's better. It's better. Jurors are not intentionally out trying to screw the carriers. The plaintiff is, and some of our judges are. I mean, I just tell you the pure facts. You get in some of those little counties and the plaintiff attorney gets what the plaintiff attorney wants. And that's just part of it. Let's move to the type of claims that they can bring. And Laura Grabouski prepared us a chart. And can everybody see that fine? This is a chart that Laura prepared. There on the left-hand column is all the causes of action that they can bring. Now, the first one, frankly, is kind of a throwaway. Well, first one, the breach of contract, they always claim it. Now, damages wise, they get economic damages, consequential damages such as out-of-pocket costs. Okay. But nothing serious like the mental anguish, and I'll address mental anguish in a second. Attorney fees, yes. If you look down that attorney fee column right quick, you get a lot of yeses and very few nos. Additional damages, you don't get tort damages such as mental anguish damages. The mental anguish damages are the ones that they're squishy. You know, we can tell what a length of pipe should cost. We know what a plumber should charge to install it. But when someone says, I was so badly mistreated, I can't sleep at night, I'm losing weight, I've got ulcers. And when a jury gives big money on that, it's hard to argue that was too much. Not that our Supreme Court won't listen to that argument, but it has to get pretty out there to be that. So breach of contract, you'll see that. Common law bad faith, we don't see much anymore. As much as anything on attorney fees, they don't get it. You get your policy benefits, and you can get some tort damage, like mental anguish for individuals. But the plaintiff lawyers don't need this common law bad faith to get to the mental anguish, okay? You can get 2 times economic damages out of it. And non-economic damages are capped at $750K. All right, the next one down, the Deceptive Trade Practices Act, or what we call the DTPA, is the one that really gets used the most. Now, normally a petition will come in and it may plead all 5 of these things. That's not unusual. But it usually gets down to the DTPA before we're all done. Damages, you get economic damages, that's policy benefits, and out-of-pocket costs, yes. Attorney fees, yes. There are some limitations that under 542A, but not big ones. Then the additional damages, see, they get the mental anguish damages for individuals. And then they get treble damages for a knowing violation. Well, folks, when the jury decides you've mistreated the insured, which on the jury, they're all insureds, they're going to determine it's knowing. So they'll get 3 times mental anguish and 3 times treble damages on the rest of it, the actual. They don't get 3 times on the attorney fees, but again, it all comes under intentional violation. Next is statutory bad faith, unfair settlement practices. You get actual damages, policy benefits, you get some limitations. There you get up to treble damages too, including mental anguish. But again, remember, it's the DTPA they go for. Then there's the Prompt Payment Act. This really just covers interest. Normally in Texas, you get 18% on your claim, which is horrendous. In storm claims, like we have now with the big freeze, and real property, it's limited to 10%, okay? May not sound like a lot, but it's a ton. You take a $10 million actual damage each year, it's still going up at $1 million a year. So in the storm claims, the interest is 10%. Now, if the car got crushed out in the driveway by the tree full of ice, I believe the 18% applies. Laura may correct me on that later, but I always treat it like the 18% applies. Now, if you want a copy of this, let Laura Grabouski know, and she'll send you out a copy. Oh, while I'm thinking about it, and most of you on here probably already have it. We also have the link to send out for our heat map, or we call it a favorability map for Texas. Let Laura know that, and she'll attach that to there too. And yeah, we'll send that out to you. We also have a mouse pad that a lot of claims professionals like to use, because the mouse pad has the state of Texas on it. It has that same map you looked at, and it has the counties listed below. On that heat map on our website, we didn't show it today, but if you go down below the state outline is the name of the counties in alphabetical order. So if you know the county the incident occurred in, that's how you find the county, because you'll never find it off the map just trying to go up and figure out which one is Nueces County. But you go down below, you click on Nueces, and the county pops up above. There's JJ's way ahead of me. Show them Nueces. Yeah. Good job. Now go back up. I don't know if it'll stay lit after you let off of it, but when you're at your website, you can pull it up all at one time. Because you're looking, the map's up above, you find them. Now, when you go in there, you're going to find out a lot about the county. See, there's the county seat. That's just hold on one. Junction favorability. Get down there in the valley there, JJ, down there in the red, the low red. Yeah, Edinburgh, extremely unfavorable. Future favorability. We kind of prognosticate which way the county is going. And so that's what I was telling you earlier. We see it trending better for us down in the valley, but it's a long way from home. Hidalgo, boy, everybody knows Hidalgo. Extremely unfavorable. I don't know, we said trending better, but it'll be the last one to trend. All right, JJ, thank you, ma'am. I appreciate that. You're good. Folks, now I'll talk just real briefly, because I don't think anybody at this seminar cares about this part of it, because it's already been taken care of down in the state, because a lot of adjusters from outside the state have come in. There are provisions for it. There's provision for emergency licensure, and there's even provision for non-resident adjusters to come in on a one case basis and then another case basis. But that's already done. If somebody needs to talk about that, give me a holler. I just don't want to take time up with it. When we got more important ground to cover. Let's go to some real world issues. Liability under 542A election procedure. We can remove cases to federal, well, strike that. In most of the states that I operate in, Oklahoma, Arkansas, Missouri and Kansas. They still, for the most part, allow them to name the adjuster and defeat removal. Well, under 542A election, if we agree to accept the liability, whatever it may be, of that adjuster, then the adjuster is removed from the litigation, and we typically then can remove it to federal court. If you're a brand new claims professional and don't already know why that's important, I'll tell you in two shakes. Better judging, better juries, and plaintiffs' lawyers hate to be in federal because they're held to different standards. So it is critical. Don't let that election get past you. One of the things you have to agree to, though, is that the adjuster will be made available for deposition and trial. It's no problem. Again, probably not necessary for this group, but your vendor agreement with these guys coming into the state and ladies, you need to have in there that, hey, your obligation is, even after you go back to Minnesota, if you're needed for depositions or trial, you will return. Because if we don't conform, we'll lose our ability to keep that adjuster or that person out of the suit, and then we'll be back in the county court. So review your vendor agreements. Also, it's bulletins. Now, Laura is very good about following the bulletins. They come out now because of the storm. They come out with some regularity. I think the last one they're saying, and it's recommendations, it's not bad faith per se, but they recommend if you're not able to totally help your insured, or they've got uncovered items or things of that nature, get a hold of, tell them to get a hold of FEMA, or give them some options to do that. Now, I like that. I want to show to a jury, and this is how we win these. I want to show a jury that we bent backwards double trying to help out. Yes, we don't have that. If we don't have coverage, we don't help out by making coverage. But we say, hey, yeah, this is not covered, but check with FEMA. Check with X, check with Y, see what they can help with. Juries love that. The other thing, and this is critical, your response time to queries from your insured or your insured's attorney. I like to see same day response time. Same thing we give you folks. When you call us, you're going to get a call back in 4 hours, or my legal assistant telling you I'm in trial and we'll get back with you later. You need to do the same thing with your insureds. Juries expect it. And I've been in a lot of trials where the insured would take 2 months to get back with us. But in the 40 interactions, none of them were longer than 1 business day, 8 hours, maybe in the next morning, but none of them were longer. It was a defensible case, but that was a hung jury. That wasn't a straight up win. So bedside manner helps us win these cases, and also helps the plaintiff attorney go, well, this isn't our best shot. We don't have enough to dig at this adjuster. Let's kind of take our money and move on. So be sure to use that in your work. And if Laura wants to talk more about those later, she can. Here's one I see a lot. Texas law mandates certain valuations. Even if you only have an ACV policy. In Texas, it's calculated by determining RCV and deducting depreciation and paying ACV. Now that doesn't say overhead and profit are not a part of that. If you try to settle with them saying, well, you don't get overhead and profit, you don't get your taxes because you're ACV. Well, in Texas, that would come up under bad faith. They do get overhead and profit. Hey, I'm just a messenger here. It makes no sense to me either that somebody who has an ACV policy would get overhead and profit on a rebuild or taxes on a rebuild. I can see taxes maybe on the value, but overhead and profit, come on. Folks, I don't make the rules, I just report them. And that's what you've got to look at. The other thing I want to mention, there's a case called Elephant versus Kenyon. It's a case out of San Antonio. I think it was Laura can correct me on it, I'm going from memory. I think it's a 2020 case, maybe a 2019. It is the first case since Stowers that puts liability independent of the policy on the carrier. In that case, a lady, the insured, slid on the ice, wrecked her car. She called her husband to come to the scene and help her. She called Elephant Insurance to report the claim and see what she needed to do. And their standard sheet that they read off of in such a situation said, oh, be sure to take pictures of the scene, the damage. Sadly, her husband was taking pictures on his cell phone and someone else came along and hit the ice and hit him and killed him. That insured sued Elephant because they were performing a claims function at the request of Elephant. So they had a right to sue Elephant for damages. Even if it had turned out there'd been no policy, if they call and you give them the advice on what to do and they do it and they get hurt under Elephant, you may be sued under that. Now, the good news is that has not gone up to the Supreme Court yet. It's up there. Laura checks all that stuff daily. I don't expect anything really soon, but Laura, if you have some better knowledge on that than I do. Now, how does that apply to our storms? Again, it's probably a little late now, but if you remind your insured that it's their duty to protect their asset, and they say, well, my roof is leaking there over the garage like a sieve. Well, sir, it's your duty to protect it. So I suggest you get up there and put a tarp on it and preserve it. So what happens when grandpa falls and breaks his back or worse yet dies? Because you told him to get up on the roof. Under Elephant, you'll be sued. So what I'm doing for my clients, I'm checking each one of their policies at their request. And I'm having them give the policy language to the insured that this is the obligation under the policy. And it doesn't tell you you have to do it yourself or not to do it yourself. It just says this is your obligation. I might even go so far as to recommend they get someone to cover that for them. And under some of the policies that we look at, that's a covered item. They get reimbursed for hiring someone to come out and cover their roof. But be aware of Elephant. It is the elephant in the room for a while. And it may tell us a little bit about where our Supreme Court's going. If that comes back and they overrule that, the Texas Supreme Court, then they're still in good shape. If they don't, well, then of course that makes good law. A few last items, because I have gone, as I am wont to do, I have gone way too long. Couple last items I'll leave you with. To the jury, your insured is never wrong. They may be mistaken, but they're never wrong. So you'd never get any points by being rude, late, tell them they don't know what they're talking about. You really just got to kill them with kindness. I mean, that's what the file needs to reflect. We get into a lot of arguments on valuation. And here's the new one. If you've not seen this yet, it's going to come your way. A lot of the PAs out there, bless their heart, use Exactament. It's the biggest in the country, and actually it's the one most claims professionals have learned on. But a lot of my clients don't use Exactament. I had a case where MKA, which has their own proprietary system, manages the cost in that fashion. Part of the suit was that we were trying to cheat the insured with using an MKA proprietary when everybody knows Exactament is the gold standard. And damn, if you don't use that, folks, you know this. All of those programs are garbage in, garbage out. There's not a lot of variation there. Exactament definitely has its weaknesses on major claims. On home claims, not so bad. But Exactament doesn't give you the economies of scale very well. So that's kind of the new thing I'm seeing. And folks, I apologize because I've overstayed my welcome. And I hope I've left some time, Laura, if there's been any questions.
Well, thank you. No, that was very informative. I do have a question for either you or Kristen. Why do you think that the DTPA has eclipsed bad faith in the way that it has? Why does everyone bring DTPA claims?
Well, well, Kristen, you want that or you want me to take it?
Go ahead and take it, Steve.
Okay. It's got everything. I mean, you know, it's your Cadillac model. It's got your satellite radio, and it's got your sidewalls, and it's got, you know, every place that the plaintiff attorney can have their hand out, it's got it. So it is anytime I get a bad faith case in that doesn't have DTPA claimed, I know I got a rookie on the other side because that is just the way it goes in Texas.
And you can bring both a DTPA and insurance code, and they're always plugged together, right?
Yeah. And that chart that you created, I would say out of those, I think there were 5 items, 4 of them, 80% of the time, 4 of them are in it. And we start weeding through them as we get closer to trial or closer to mediation, and they may dismiss them but it's, I've yet to have the DTPA be the one dismissed. So.
Okay, very good. Also, I saw a recent case where the court said the adjuster had a reason, but it wasn't very good. They said it was a pretextual denial. Do you see that a lot where it looks like a valid reason, but it's scrutinized and it's just dismissed out of hand by the court?
Yeah. Again, Kristen,
It's all good, Steve.
I appreciate that. Yeah, I mean, it's pretextual is in the eye of the beholder. And, you know, yeah, they're going to call it pretextual. And if there's any insinuation in the file that, well, let's tell the insured, give them an answer here because our date's running. We're not done reviewing. It's like, well, that's pretextual. You told us you had problems, but you hadn't done your work. I mean, it's just a landmine area.
I see.
Laura, I hate to cut you off. A lot of these people in here are my friends. At least I consider them my friends. And you know, when we said we were going to keep it to an hour, I want to do that. Now, if anybody wants to stay around and has a question, we're going to answer them. And if not, we're going to reach out to you and send you an email or call you. We may even put it on our website, the question, not your name, the question and the answer to it. It's important to us that we help out where we can. I call it a 5-minute curbside consult. We answer questions all day long that take about 5 minutes. I get questions about Nueces County about 2 times a year. Yeah, I'll tell you in 5 minutes what the problem is. Laura and Kristen the same way. If it's one of the research and writing areas, definitely Laura takes care of that. JJ, do me a favor too before we let everybody go. I just noticed I was drinking out of my favorite mug. It's the Holden litigation mug. You know, we don't blink. I've got several friends that just love that. Actually, I got it because I went to a state park and it's the best insulated mug out there. I kid you not. You got to leave the lid off for the first 30 minutes so it cools down and you can drink it. But send that out to everybody on here. And I tell you, if you want it, let Laura Grabouski know where to mail it to. Because if we mail things to your offices anymore, they don't land very well. But we can send that out. Send a pad out to JJ. We got the link because that's a mouse pad of the state comes in real handy. So if anybody wants it, it's we got your swag. We're swag central. All right, folks. We're going to hang around, but I know a lot of you will have to move on. And so, Laura, let's JJ. Make sure we're not just sitting here talking to ourselves. So if everybody had to move on, that's fine. If not, we'll answer these questions and any they have until we're done. Go ahead, Laura.
Well, I don't see any in the Q&A. Maybe we'll get some by email, but that may wrap it up, Steve.
Okay, I thought there was some others. So I did get one about the election to accept defensive adjuster, but I covered that in my presentation. But someone was.
Yeah, that's all I saw.
Okay, all righty. All right, well, let's sign off then. And for the attendees, greatly appreciate it. And hope we can be of some service in this. Bye-bye.
Thank you.